of the voters' roll in 1998, the Electoral Commission has held the view that disenfranchising a voter on the basis of a lack of a formal address would be unacceptable in a country where there are millions of people who live in informal settlements and in rural communities where there may be no conventional address. This policy of inclusivity has resulted in South Africa enjoying one of the highest levels of voter registration in the world, especially for a developing country with an average of 80% of eligible voters being registered. The voters' roll currently comprises approximately 25 million voters, and of which the breakdown is as follows. Approximately 36%, which is 8.7 million, have a full conventional address. And 32%, which is 8 million people, have a partial or generic address. And approximately 32%, which is 8 million again, have no conventional address details. Following this Constitutional Court judgment in November, the Electoral Commission had undertaken a range of initiatives to ensure that all new registrations include address details or at least sufficient particulars of the voter's location so that we can be able to place them in a voting district. These measures included introducing a new supplementary form to the registration process for voters who do not have conventional addresses, in which they can affirm their location in a particular voting district. The Commission yesterday therefore resolved to do everything in its power to encourage all voters to update their details on the voters' roll ahead of the 2016 municipal election. And among these measures to be considered include the reviewing of the REC1 form application to ensure that all address and details are provided and that were provided have been accurately captured. And secondly, contacting all registered voters that we can possibly reach in the given time, for whom there are currently no address details, to request them to provide the Commission with an address, as well as conducting targeted door-to-door campaign of registered voters without addresses on the voters' roll with a view to obtaining address details. And lastly, investigating all possible alternative sources of address information for voters, including from public and commercial sources against which addresses can be checked for the voters. These measures will be supplemented with a general communication campaign to inform registered voters of the address situation and appeal to all registered voters to use the upcoming registration weekend to verify and update their registration details. All voting stations will be opened as planned this weekend, which is the 5th to the 6th of March, between 8 a.m. and 5 p.m. for all eligible voters to register or re-register and to update. The Electoral Commission will also provide details of its state of readiness for the weekend registration for this coming weekend, later this week. The Commission is also considering additional opportunities for voters to register and update the information ahead of the 2016 municipal elections, and will continue these plans in due course. We therefore will not leave no stone unturned to see what other measures and what other mechanisms can we bring into to bear to ensure that we still meet the constitutional timetables as far as the 2016 elections are concerned. The Commission will seek urgent engagement will also seek urgent engagement with the leaders of political parties represented in the National Party Liaison Committee and other key stakeholders this week to brief them on this decision and its preparation for the postponed by-election and municipal elections. The Commission therefore appeals to all stakeholders for their cooperation and assistance in spreading the word to all voters to use the upcoming registration opportunities to register and to update their registration details. And I thank you.
Thank you very much, Chairperson. I'm going to open the floor for questions. If I may ask, whoever is asking a question must please introduce themselves, as well as tell us where which media house they're coming from. I'm going to take the first 3 set of questions, and then the panel from the IEC will assist in answering all of these issues. Let me take questions from this side. Andrew?
IEC Chairperson Vuma Mashinini, who has been briefing the media on the Tlokwe by-elections, and there's been a decision to...
How soon must the Constitutional Court give a ruling or provide clarity on this matter so that it doesn't interfere with the IEC's obligation to run the municipal elections this time around by the 16th of August? And in terms of the addresses, what would it take from the IEC's point of view to assert itself or to satisfy itself that it has sufficient details of the voters or the electorate on its voters roll, the 32% that we were speaking about who don't have conventional addresses?
Any other question? All right. We'll deal with Aldrin's questions. Sure.
Yes, no, thank you, Eldrin. That's a very good question. As far as the Commission is concerned, we have no control on the Concord's decision and its availability. However, we hope that we will have the matter heard urgently. And then on the second question, I would ask my Vice Chair to actually respond to that.
Perhaps if I could just indicate one aspect that is important. There seems to be an understanding among some within the media that the process that we're involved in may lead to the postponement of the elections for 2016. And that question was raised by Aldrin to say that this court matter is related to whether we're going to have the elections within the constitutionally stipulated period or not. I must indicate here, from the side of the Commission, there has never been a consideration to postpone the election. That question has never arisen, and it will not arise. We are confident that we'll be able to deal with all the issues that we're supposed to be dealing with, and we will then be able to deliver the elections within constitutionally stipulated period. And I think it's important because there is a narration that says otherwise, particularly in the media. And when will we satisfy ourselves that we have been able to capture sufficient information for the voters to say, now we've got the addresses? Obviously, if the court says that every voter must have an address, we've got to make sure that every voter has got an address. But also you will notice that an aspect that has been important in that the court has indicated to us that they want us to find sufficient particularities in order for us to be able to place a person in a segment of the voters' roll. So all the efforts that the chairperson spoke about today are efforts aimed at ensuring that we get sufficient particularities that will be able to enable us to put a person into a segment of the voters' roll. So to that extent, we are obviously aiming for 100%, as the court expects us to do 100%.
Thank you, VC. Are there any other questions of clarity? That Clement, and then...
Francis Clement from NSL. I just
which suggests in this case that there may, as you say, Chair, that there would be parallel processes, or these processes would be run concurrently. Why would you do that? I mean, given the outcome of the Constitutional Court, if it doesn't go your way, may have a bearing in the end on what you have done as a parallel process.
Ready? Any other question before we reply to the questions already raised? Right, let's proceed to the answers. Local by elections, Chair.
Yeah, thanks. I would request the CEO to respond to the first question, and then the Vice Chair to respond to the second question. Thank you.
First, do you want to deal with both?
No.
Okay. You can deal with the first, and I can deal with the second.
I think it was made clear in the statement to say that there are certain elements of clarity that would be sought. But in respect of the work that the Electoral Commission is doing to obtain the details of voters, the Commission continues to do so. Once the court has pronounced or given as requested by the Commission, we will also take that into consideration. But no work stops whilst these processes are underway. Thank you very much.
Okay.
Let me indicate something that is very, very important. When we were found wanting by the Electoral Court, when this matter first appeared before the Electoral Court, you will recall that there was a minority report of Judge Weppenam. That minority report was saying that we should do certain things in order to improve on the voters' roll. And then, as you recall, that the Constitutional Court eventually overturned the Electoral Court judgment. But nevertheless, from our side, when we are looking at the electoral processes, we still went further to a judgment that was overturned by the Constitutional Court, and then we took that information that we believed could improve our processes. So in our case, the most important thing is, because we run in this business, we understand that every little element, everything that is being said is important in terms of improving our processes, and therefore we will take whatever elements that we have that will improve our processes. So even on this case, where the issues are still being contested in court, where we still require clarity, from our side we must still be able to do every little thing to perfect our voters' roll. That's what we do on a daily basis, and will continue to do so. So the judgment does not necessarily mean that the fact that we are taking it to the Constitutional Court, therefore we should actually now stop doing all the work that we need to do in order to ensure that all these processes take place. There's got to be an election in Clogwe. The people of Clogwe have been waiting for the elections for a long time now, and then there are other elections, by-elections that we have postponed. They must also happen. So we are continuing with our processes as we proceed with this. And the fact that we are appealing to the Constitutional Court does not nullify other processes that we have embarked on as an organization.
Having said that, I think further it is to be in a position that we are clear that in cases where people then do not have the addresses, suppose a person is a destitute person, does not have a home, does not have an address. What does the judgment mean? Suppose a person, as some people have already indicated, that they feel it is their constitutional right that they should reserve their privacy, and yet we are required to give the political parties their addresses. So you have a number of things that are all constitutional rights. If you apply one, on the other side you may be actually in contradiction to another. So in this environment, the order should be very clear from an operational point of view, and from our side is that it should be clearly possible for us to say what practically then are we supposed to do without finding ourselves again being challenged or being at foul with the law. because the objective here is to ensure that we as an institution, we conduct free and fair elections and the outcomes are acceptable to all the parties and leave no room for any particular individual or individuals to feel that they have actually been disadvantaged or otherwise. So there are those, we're not going into the details because we are still in consultations with our legal advisors, but we're just saying in a broad framework, we are seeking this facility for that particular purpose, for clarity.
Let me take the last round of questions before we wrap up. Tabiso?
Just as a follow-up, could you also provide us with the details, the breakdown? The matter that has brought us to this state is related to the 7 roads in Togo. Can you give us a breakdown in terms of what you have there, in terms of the people that have registered to vote? How many of them constituted what you call the full conventional addresses, and so on and so forth? Can you give us details in order? And then maybe if you could also clarify, how long would it take you in that regard to have finished that process, and what would you provide them with that information later?
Respectfully, Tabiso, those particular details, we can refer them to the Deputy CEO if you need those details, and he'll provide as much information as we have. But I think the picture is not about just Tlokwe now. I think we need to understand that we are talking here the country. We are saying 2/3 of the people of this country, in the strictest sense of the Electoral Court ruling, we may have some constitutional challenges or problems. And 2/3 is one too many. And the implications of that is what we are now working and grappling with to say, how do we resolve this? But we are still going ahead with the preparations as planned, and for us, for both the by-elections that were postponed and the ones that are still outstanding, as well as the 2016 municipal elections. So I think the Clockwood decision is a decision, but the most important thing is the implications of it for the country. It's no longer about just Clockwood. And you do have that stat. 2/3 of our people do not, at this stage, meet the technical, the rulings requirement. But we are working and leaving no stone unturned to actually ensure that we optimally accomplish or achieve that particular exercise. Thank you.
Alden, I see your hand up. I was just about to wrap up. All right. Let's hear you out.
It's a bit confusing, though, that you have this electoral court ruling that you decided to postpone the elections not only in Togo but in the other 3 provinces as well. And you are challenging this ruling, yet you are going ahead with preparatory work in Togo, for instance, more specifically because the matter related to Togo. I fail to understand that how do you go ahead with preparatory work to get forward with the by-elections in Togo and the other 3 provinces, yet you seem to be challenging that electoral ruling that has brought you to this current place. And then just 2 other questions. In terms of budgetary cost, what cost implications are there for the IEC if you had to satisfy yourself that you have 100% where you feel that everybody has an address? And the final question is, the integrity of this institution has been dealt a blow. Speaking to the independent candidates in Togo, for instance, they say there's no way that they can trust the IEC again heading forward.
Right. Thank you. I think with respect to the question of trust or not trust, look, it's a subjective matter. We are putting it before every South African and putting it to the nation that the Electoral Court has made a ruling. That institution is part of our fabric as a democracy, and we will abide by the decisions of the courts. All what we are saying is that for us to implement, there are a number of matters that would need to have a clarification on. The only mechanism that you have to do that, you have to appeal the matter. It's not that we are fighting or we respect the courts. But there are certain procedures now legally that and processes that we need to bring about. And I'll ask my, our Vice Chair to respond to the other questions. Thank you.
I can understand and appreciate the confusion that exists in your world, Adri. But from our side, we've been given a judgment that says we should have an election within 6 weeks. Yes, there are certain things that we believe require some clarity, and those matters that require clarity must be clarified. But we are operating within a time frame that has already been set by the Electoral Court. And it is 6 weeks from the time when judgment was made. Now, if there is an understanding that our interpretation is correct, then it is okay. We're still having the election anyway. But if we can find that we were wrong in terms of our interpretation, and we had not prepared to meet the deadline as set by the Electoral Court, then we will be in trouble again. So we're trying to make sure that we are balanced in a manner that we're dealing with the issue. But you will recall as well that following the Constitutional Court judgment, we went to Tlokwe and started putting in place some innovative mechanism to make sure that we can have an election in that area. We used landmarks, for instance, where there were no addresses, but obviously we did not capture as many people as we wanted to capture, because not everybody goes to update their details, not every person goes to change their voter registration details once they have moved houses. So we are going again, using the same strategies that we used, and hopefully we'll be able to capture many people. And by the time we go to the elections in 6 weeks' time, it will be easy for us to be able to show to the court that we've actually been able to comply with their requirements. There is no way to say we're going to stop doing the work that we're supposed to be doing because we have taken the matter for clarity at the Constitutional Court. And as the chairperson has indicated, there is no animosity between ourselves as the Electoral Commission and the courts. Those are some of the instruments that are there within the electoral law that are helping us to ensure credibility and integrity of our processes. So every time when there is a judgment, either in our favor or against us, it does not mean that there is something wrong with the process. It is just, as it happens internationally, mechanisms that are there to ensure integrity and credibility of the elections, and we take those seriously as part of our process. Just as much as people can also object against the decision of the CEO, and the Commission has got the latitude to deal with those objections. It is another instrument that is there in the law to make sure that our systems operate and operate efficiently.
In respect of the postponed by-elections, you will recall that what has been postponed is the election day. And in that respect, it really is the cost relating to staff for election day. But depending on the clarity that will be sought from the courts and the work that we may be required to do, or clarity that we have obtained, we will be able to review the budgetary costs, and we'll share that with yourselves in the media as may be appropriate.
Okay. Justice Clare.
Okay. Reverend Finn.
Yes. Yeah.
Thank you very much, Chairperson. Just from the perspective of understanding why it is important for us to go to the Concord. I was just saying to the Vice Chair now, one of the key questions that bothers us, which is not clarified, it can only be clarified by the Concord, is that there are people who are on the voters' roll, who have been on the voters' roll since 1998 when we started to compile it, who have not provided addresses because they don't have them. We need clarity from the CONCORD on what to do with those people. Does the CONCORD want us to remove those people from the voters' roll so that the voters' roll is 100% compliant with addresses? Is that the direction that we want to take? So we need those clarities. There are things that are clear now, but there are things that are still not clear, that the CONCORD must still clarify for us in order to do our work.
Thank you.
Thank you, Reverend Finger, for that clarity. Ladies and gentlemen, let me bring this press briefing to an end. I'm hoping that all the questions of clarity have been dealt with. Any other additional information we'll definitely provide on request in terms of the processes for this afternoon. On that note, thank you very much.
Thank you. Thank you, sir.
Thank you very much.
Thank you.
I think this one is yours. What happened to mine?
I know yours is nicer.
No, it's not the niceness. It's just like, but